Okay, so let's begin. My name is Anne Saab. I'm an associate professor of international law at the Geneva Graduate Institute, and I'm really delighted to welcome you today for this briefing on the ITLOS advisory opinion. So as many of you, I suppose, would know, the International Tribunal for the Law of the Sea delivered its advisory opinion on climate change on the 21st of May, which is exactly 2 weeks ago today. And we're really thrilled that we have this opportunity today in this online briefing session to reflect on some of the initial responses to the advisory opinion with legal experts who have been involved in this case. And we're also going to cover some of the background of the case and the process leading up to the delivery of the court's opinion. So I'm going to introduce to you first our speakers who are here with us today. We have one of our speakers can't join us live in this session, but she has pre-recorded a video which we're going to show you. Charlotte Ruzzica de la Chaussée, who is part of the Commission on Small Island States on Climate Change and International Law, which submitted the request for the advisory opinion to the ITLOS. Then we have with us here Tamara Morgenthau, who is a senior attorney with the Center for International Environmental Law's Energy and Climate Program, based, I believe, in Washington, if I'm not mistaken. Are you based in DC? Yes. We also have with us Louise Fournier, who is legal counsel at Climate Justice and Liability at Greenpeace International. And we have Samira Ben Ali, who is Outreach and Engagement Coordinator at World's Youth for Climate Justice. So welcome, and we're really delighted to have you here. We also have our discussants who will be posing a few questions to our speakers. We have Leisa Branco, who is a PhD candidate here in the International Law Department of the Geneva Graduate Institute. And we have Joachim Streleski, and I hope I pronounced that correctly, who is a master's student in international law, also here at the Geneva Graduate Institute. So let me just give you a little bit of an overview of how we're going to run this briefing. So we're going to start shortly by showing the video that Charlotte recorded for us for the purpose of this briefing. I should say that the recording was a little bit longer than we are able to show here. So Charlotte already indicated which section we can sort of cut off in case it is too long. So we're not going to be able to show the whole recording, but we're going to show the main parts of what she has shared with us. Then I'm going to ask the speakers who are with us today, Tamara, Louise, and Samira, an introductory question to get a sense of what their engagement has been with this advisory opinion. And then Leisa and Joachim will pose a set of questions to each of our speakers, and so hopefully we will get a good sense of the advisory opinion. If I could also maybe ask everybody to mute themselves if they are not speaking, just so that we don't have background noise going there. All right, so let's get started. If I could ask Ruth if you could start the. Yes, there we go. So Charlotte is our first speaker.
Good afternoon. My name is Charlotte Ruzzica de la Chaussée. I'm an international lawyer based in the Pacific, and I've been fortunate to be part of COSIS since its inception in 2021. I've participated in the establishment of COSIS at COP26 in Scotland, and I was also part of the legal team that represented COSIS at the September 2023 hearing in Hamburg, and I also helped with the communication strategy there. So I'm now working with the newly established COSIS Secretariat, but I emphasize that my remarks today are in my personal capacity. So first and foremost, I'd like to thank the Graduate Institute for this opportunity to speak about the background of this request and the process that led to the issuance of the opinion. I'm also delighted to be speaking alongside eminent CSO colleagues with whom I've worked during the process leading up to the issuance of this AO, and whose insight, I must say, have been invaluable to my work. I would like to salute the dedication of these individuals who have worked hard and freely for our noble cause. So first, to give you a little bit of background on the Commission, COSIS is the story of two visionary leaders, Prime Minister Brown of Antigua and Barbuda and Prime Minister Natano of Tuvalu, whose nations are to be soon submerged in water, that's for Tuvalu, due to rising sea levels, or exposed to the complete destruction of the islands by typhoons and extreme weather events that intensify year by year, and we've seen that in Antigua and Barbuda, including with the Irma typhoon in 2017. So in 2021 they decided that they had had enough of COP negotiation processes, I must say, Vanuatu empty promises by the polluting states, and well, they were facing increasing difficulties due to climate change back home. So they decided to set up an intergovernmental organization, that's COSIS, made up of AOSIS states, to explore the legal avenues to see what international law had to say about climate change and the legal obligations of states, including polluting states, because after all, there are numerous instruments of international law that exist on this subject. So they turned to the law and to the courts as their ultimate recourse. So now I can maybe tell you a little bit of the informal story of the creation of this intergovernmental organization to add a little bit of spice to the presentation. So in fact, it wasn't easy to find two heads of state who would agree to take on this battle. You can well imagine the pressure exerted by the polluting states on the small island states, as you know, they're providers of development funds and they greatly influence the global political agenda. So it's a bit the fight of David v. Goliath, right? So it's easy to understand that a country with a population of 10,000 or 100,000 respectively is a small voice in the international debate compared to a country with a population of 400 million or 1 billion. So you'll understand easily that it takes courage for states to sign such an agreement. So it took time for Antigua and Barbuda to find a partner to establish the commission, but fortunately Tuvalu decided to rise up to the challenge just in time for COP26. So there, the start of the organization had to be drawn up very quickly, and believe me, it was a real challenge to find a room to organize this official ceremony for the signature of the founding agreement, and then the day before the opening of the conference, so of the COP26 I mean. So we found the room in Edinburgh and had to organize the protocol so that the heads of state could come travel to Edinburgh from Glasgow with their security personnel. Shortly after the agreement was signed, Palau signed up at COP26 too, becoming a third member. So we had 3 members of the organization by the end of the COP26. And after that we had to register the organization with the UN, organize on-site media coverage, which turned out to be a success because COSIS was featured as one of the main hopefuls when commentators analyzed the successes of COP26, and I don't know if you remember that. That's about 3 years ago, right? So next, the Committee of Legal Experts was set up with 14 experts, and to cut a long story short, the Commission requested an advisory opinion from ITLOS on December 12, 2022, about a year after its creation. Subsequently, we had 6 additional members, Caribbean and Pacific states of Vanuatu, Niue, the Bahamas, St. Kitts and Nevis, St. Vincent and the Grenadines, and St. Lucia that joined. And Vanuatu, I must say, Vanuatu joining was absolutely essential in affirming the complementarity of both the ICJ-AO and the ITLOS AO, which were otherwise seen as competing, which actually was never the case, because, you know, they really reinforce each other, and we hope that this ITLOS AO will serve other procedures, other AO procedures. So it made perfect sense for the island states to bring this case before the tribunal, as it's important to remind that they are large ocean states whose societies are traditionally seen as the guardians of the ocean, and whose cultures are permeated by the presence of the ocean. They suffer like no other state from the destruction of the marine ecosystems that are their source of sustenance. Their economies suffer, their food chain, their biodiversity, their infrastructure and society as a whole suffer the consequence of a changing ocean and a degraded marine environment. So now in the second part, I would like to talk about the process leading up to the opinion. So in procedural terms, we had in December 2022 the request that was submitted, as I just said, by COSIS. It was accompanied by a dossier of documents. So basically the two questions come with the UNFCCC framework and the Paris Agreement. And then from then, all 168 state parties to UNCLOS were notified by the registrar of the court and invited to submit written statements on the issue by June 16, 2023. The tribunal also invited intergovernmental organizations likely to be able to provide information on the subject. So these two could provide written statements by the same deadline. And we had a record number of 34 states and 9 intergovernmental organizations that submitted written statements, which is absolutely unprecedented in the tribunal's history. So COSIS submitted its written statement, accompanied by 2 expert statements based on findings of the IPCC. This time the tribunal decided to hold a hearing, which is not always the case, and the historic hearings took place over 2 weeks, starting on September 11, and in fact COSIS had 2 full days of pleadings, and there an unprecedented 33 states and 4 intergovernmental organizations took part, which is huge. Some of you may remember if you've attended in person. That was quite an event in Hamburg, and then the tribunal drafted its opinion in a record time of 8 months, and as you all know, this opinion was delivered at a public session on May 21, 2024, so about 2 weeks ago, and was a truly historic moment for climate justice. It was adopted unanimously by the 21 judges, and so I invite you to read the 150 pages of this opinion if you have a little bit of time in your studies. So now I would like to finish by a presentation.
So I do apologize for cutting Charlotte's presentation off, but this was the point where she indicated, okay, if we don't have enough time to show the entire video, then this is the place. This is the place where we can stop at this part. So she does continue and go into more detail on what the advisory opinion, on some of the main parts of the advisory opinion, and I wanted to just tell you what Charlotte shared at the end of her presentation, which is very relevant. So she emphasizes at the end of her presentation that the work of COSIS has really only just begun, and there's a lot of advocacy work that is happening on the part of COSIS to spread the message of the advisory opinion. So it's not as if the work is now finished. Now that the advisory opinion is out, there is a lot of work still to do for COSIS to make sure that the advisory opinion gets the attention that it needs to get. So Charlotte welcomes you all to reach out to her via email. You can get in touch with me in case you want to get her contact details. So she invites you to reach out to her with suggestions for potential networks to tap into, for suggestions for where the advisory opinion can be brought to attention. So I think that's a very important point, that this isn't sort of the end, but it's really the beginning. So thank you very much, Charlotte, for recording this video to us in a very appropriate setting and background for the case we are talking about. So let me now turn to an introductory question that I'd like to pose to all 3 of our live speakers here with us. So I would like to ask of Tamara, Louise, and Samira, if you could introduce yourselves in a little bit more detail than I have, and to tell us what your involvement has been with the ITLOS advisory opinion and from what perspective you've been working on this. So maybe we can start with Louise and then Tamara and then Samira.
Of course, thank you so much. And hello, everyone. Good morning, or good afternoon, or good evening. It's really a pleasure to be here, and thank you so much for joining us and for the kind invitation. So my name is Louise Fournier. As Anne told you, I'm legal counsel at Greenpeace International. I'm working as part of a legal team that works on various climate litigation matters, whether it's at the international level, which fortunately is happening a lot more this year and last year, or at the domestic level. The majority of the cases are actually cases at the domestic level that Greenpeace national and regional organizations are either plaintiffs of or they're supporting. And so it has been really quite busy the last few months for us. We just had the massive victory as well in the Klimaseniorinnen at the European Court of Human Rights, and now with ITLOS. And together with Tamara, we're collaborating a lot with the Center for International Environmental Law, CIEL. And for ITLOS, we decided to submit an amicus brief last year, knowing, of course, that there's no formal process for amicus briefs in the ITLOS proceedings, but also hoping, and we got our hopes realized, that the tribunal would still transmit our submission and share with the parties involved and put it on the website, and we can share a link to our submission. But just to say that we were seeing at the ITLOS submission in light of the broader objectives of what do we want to achieve through all these international courts and tribunals. And specifically for ITLOS, we came up with 3 objectives that we wanted the brief to achieve. We wanted to establish that there was judicial notice and understanding that the best available science is the basis for decision making, and also for examining the adequacy of measures or the adequacy of due diligence obligations. And in that, we really wanted to highlight the necessity to keep global warming to below 1.5 degrees, knowing what are the impacts at current levels of warming, but also at 1.5 and of course beyond 1.5. We also wanted to establish that the duty of states to prevent, reduce, and control pollution of the marine environment under UNCLOS is actually informed by other areas of law, in particular by human rights law and international law, such as the precautionary principle. And we wanted to establish the due diligence obligation of states under UNCLOS to also control private actors' marine pollution. And therefore, a large part of our submission focuses on harmonious interpretation and looking at other sources of law. And we start by saying and showing ITLOS that it has actually used human rights standards in previous instances, including in a case in which Greenpeace was involved, the Arctic Sunrise case, and in other cases. And then we also go into more detail in terms of the climate agreements and what they mean. And a large part of our submission is also what is the best available science at the moment, and why it's necessary for states to actually act urgently to keep warming to 1.5 degrees. And then we go into more specific measures that states should take, in which Tamara will tell you more about.
Thank you so much, Louise. So Tamara, same question for you.
Great. Yeah. Hi, everyone. Yeah, it's great. It's great to be in this discussion with you. Just briefly introduce myself. As Anne said, I'm a lawyer with the Center for International Environmental Law. And there my work, broadly focuses on protecting human rights in the context of the climate crisis. And that includes, by developing and supporting legal and advocacy strategies. And so one of the areas that we've been working on is, supporting the different advisory opinion processes. And so I will, to pick up, I guess, where Lou left off in the context of our joint brief, I'll discuss some of the specific measures that we, that we advocated for, and show you a little bit how those played out in the decision. So, broadly, one of the, as Lou said, one of the things that we put forward is that if you were to interpret the provision to protect and preserve the marine environment, that requires states to minimize further warming and keep global temperature rise below 1.5. And we also said that there's also an importance of measures here to adapt to the changing climate and the adverse effects from greenhouse gas emissions. And so we provided some detail on what that actually means states must do. And, we can't go over all of them, but just quickly to highlight some, we put forward that if you interpreted all of the different bodies of law harmoniously with the provisions of UNCLOS, it requires states to implement urgent and ambitious reductions in greenhouse gas emissions, which includes by immediately phasing out fossil fuels. We said that it requires states to, regulate and mitigate the activities of private actors. It requires comprehensive climate analyses through environmental impact assessments. It required states to, take action urgently and rely on measures that are known and capable to avert the harms from climate crisis, as opposed to relying on speculative technologies. And we also talked about the need for high income and high emitting states to take greater and faster emissions reduction measures and support the adaptation and mitigation efforts of states less responsible for the crisis and greenhouse gas emissions. And so, as we'll discuss today, a number of the points that we advocated for as the required measures per the UNCLOS Convention are either explicitly or implicitly provided in the opinion. So the opinion, it does talk about the need to be guided by the best available science and recognizes the limit of 1.5. It also talks about the mitigation and adaptation measures. And while it didn't explicitly state that the phase out of fossil fuels is required, our reading is that it's really the only conclusion that you could draw from applying the analysis and the guidance of the opinion. So I will leave it there. Thank you.
Great. Thank you so much, Tamara. So Samira.
Hi, hello. Thank you again for the invitation. It is really nice to be here and to represent a youth organization that I'm part of, that is the World Youth for Climate Justice. So the World Youth for Climate Justice is an organization that specifically works mostly on the ICG advisory opinion on climate. That's the way it's thanks to that advisory opinion and the work that we have done through that advisory opinion that the organization has been able to form itself. And because we have such an interest in this advisory opinion, and because we know that it is important to also be knowledgeable of the other advisory opinion, and that's why we also decided to look into the ITLOS AO, but also the Inter-American Court advisory opinion. We did not submit an amicus brief, but we made sure to be present during the whole oral and during the delivery to make sure that the messaging that is done by the court, the AO, is also text that can be read by the youth and understood by the youth. So what we have done for this particular advisory opinion is really making sure that this is understandable to different communities. And for the other advisory opinion where we participate more actively, the messaging that we have been advocating for is one for human rights, but also specifically for intergenerational equity. So yes, that's mostly our work when it comes to those AOs.
Great, thank you so much for those introductions. So I'm now going to hand over, I think, to Lisa first, if that's correct, and maybe I can just check because just check with Lou and Tamara. We had planned to ask Tamara the questions first, but would you prefer to have the order for those questions, or it's fine to keep it? Well, it's fine to keep it. Okay, great. So Lisa will now pose a set of questions to Tamara, and then a set of questions to Louise, and just so that the audience knows what's happening as well. Lisa will ask more than one question, so really a set of questions to each of the speakers. And the idea is not that that the speakers respond to every single question in detail, but really to speak to the broad themes that are identified. So Leysa, the floor is yours.
Yeah, thank you. I hope you can hear me. Thank you, Tamara and Louise, for your brief introductions. I guess some of your comments perfectly adjust to the questions that Joaquin and I prepared for you. So I'll just move right into the questions for Tamara. You've mentioned adaptation, which is a concept that you can't really find in UNCLOS, but we were thinking of another principle that is well established in climate change, but for law of the sea, some scholars are not necessarily familiar with, which is the principle of common but differentiated responsibility. And so the tribunal did mention for the first time that there are in fact some connections under UNCLOS with this principle. And it was referring to marine pollution, but also the obligation to provide technical assistance. So we were just wondering what are your thoughts on bringing this principle to UNCLOS, and more specifically to the prevention of marine pollution, but also in relation to providing technical assistance to developing countries. And also if you see any issues regarding this economic category of developing versus developed states, or whether it would be perhaps better to kind of create a context-oriented approach to this and focus on vulnerable states, for example, instead of just kind of a broad term of developing states.
Great, thank you. Yeah, so I will, as Anne said, I'll answer those questions together. But starting with a little bit just what the court said in terms of its recognition of the principle. So the court held that, the necessary measures to prevent, reduce, and control marine pollution must be determined objectively. And it laid out a few factors that needs to be considered in an assessment of what is necessary. And so what are the measures that are appropriate in this context? And that includes, best available science. It includes the rules and standards from the international climate regime. And it also includes the available means and capabilities of the state concerned. So in that, here we see in the decision that it is uplifting equity as a key part of the convention obligations. And to zoom in a little bit more, further in the opinion, we see that the tribunal uses like harmonious interpretation to interpret provisions, including the broad Article 194.1 about the obligations to prevent, reduce, and control marine pollution, and finds that this provision does contain, and I'll quote here, some elements common to the principle of common but differentiated responsibilities. And here, it states that measures under this provision, Article 194, may differ between developed and developing states. But it's important here to also note that the tribunal clearly does state that while developed states must take the lead, which is significant and important, all states must make mitigation efforts. So it recognizes the, that there's alignment in the provisions of UNCLOS with the principle of common but differentiated responsibilities, but also really does affirm that this principle is not an excuse for inaction. So it does recognize that it may mean that implementation can vary according to states' capabilities and resources, and that the responsibilities and capabilities of developed states is, to take the lead, but it is important that it does really stress that all states have this set of obligations and need to take action. So I'm going to zoom in a little bit more on, your question around whether we can see that this principle is going to contribute to promote more and better technical assistance to developing countries in the context of this provision, or in the context of this convention. And I think there are some strong aspects of the decision that does affirm that developed states have the obligation through a number of different provisions in UNCLOS to provide different forms of support to developing countries, which it also does qualify and explain that that includes particularly those most vulnerable to the adverse effects of climate change, which kind of gets at your second point there in question around differentiation. And, you know, it also really importantly states that these obligations around assistance goes both towards mitigation and adaptation needs. So we see that this actually takes, I think, you know, a fair amount of the discussion of the opinion, where it goes through under the context of what, you know, they call the duty to cooperate, and explains that this duty does include a number of obligations and provisions within the convention that require assistance to be provided. And that assistance includes technical assistance, it includes financial assistance, it includes capacity building. It's also non-exhaustive, which they explain in the opinion. So I think, you know, it does say, particularly around Articles 202 and 203, that essentially it could, as interpreted, provide like a basis and means for, you know, sort of comprehensive support to states that have lesser capabilities and are in greater need of support to meet their obligations around mitigation and adaptation. I think it's important here to recognize that, you know, to your point about how is this going to be put in practice for implementation, you know, the opinion does discuss at a number of points that one of the obligations in the convention is for states to work together to formulate rules, standards, and recommended practices. And so potentially that could be one area that we see further alignment or development going forward around how to actually implement and put into practice these obligations. I think another point, moving to your other part of the question around the categories around differentiation. I mean, when I read the opinion, I actually don't necessarily see that there's that significant of a distinction. I think in a number of places in the opinion where the tribunal's elaborating on the assistance that must be provided, it discusses both the context of like developing states and states that are vulnerable to the effects of climate change. So maybe I'll just like highlight a couple places. For instance, you know, it says that scientific, technical, educational, and other assistance must be provided to developing states that are particularly vulnerable to the adverse effects of climate change, and highlights that that's like a means of addressing an inequitable situation. Particularly goes on to say, because although they contribute less to anthropogenic GHG emissions, such states suffer more severely from their effects on marine environment. I think, you know, in other places, I think we go on to see that they really bring those two concepts together. So again, when they're talking about Articles 202 and 203, they set out specific obligations to assist developing states, and again, say in particular, vulnerable developing states. You know, I think it's important to also note that the opinion does recognize that the devastating consequences, and I'm quoting here, it has and will continue to have on small island states considered to be among the most vulnerable to such impacts, and does that really at the outset of the decision, which I think it explains, set some of the context and backdrop for how it's going to go through what the convention obligations mean. But I also think within this conversation around this principle of CBDR, it's important to recognize, and I highlighted here some of the way it went through, like some of the obligations for assistance, but this principle is clear that it applies not just to the assistance that states have to provide, but also it's really related to both the mitigation and adaptation obligations, so that states, you know, developed states have to take the lead in their mitigation efforts. And there's a really important connection there, because their failure to do so will disproportionately harm states vulnerable to climate change. So linking those two together. And finally, I know we're not talking about this here, but I do think it's relevant and to remember as an important part of the broader conversation that, you know, the questions around remedy and reparation, while those weren't before the tribunal for the law of the sea, they are questions before two ongoing climate advisory proceedings. So the one before the International Court of Justice and the one at the at the Inter-American Court for Human Rights. And, you know, it's really important to recognize that independent of and in addition to state obligations regarding assistance or implementation around mitigation obligations that states that are particularly vulnerable to the adverse effects of climate change, as well as individuals within those states, have a right to remedy and reparation due to the harms that they have suffered from the adverse effects of climate change. And so discussions around assistance, those are critical obligations, but they shouldn't detract from the importance of the issue around remedy. While the tribunal, as I said, didn't really discuss that, the question of remedy, it did highlight that the failure to comply with the convention obligations, including the Article 194, can engage the international responsibility of states if they fail to comply with those obligations. And so that's, I think, even though it only came up really in one paragraph, it's a really critical and important part of the conversation and really connected, I think, to this principle. So yeah, I think
thank you for such a no, it was a very complete answer to this question. In fact, I guess during the interventions also the issue of historic reparations came into play by Vietnam, I guess. But yeah, thank you so much, and I guess kind of this perfectly links me to the question I would like to pose to Louise. Which is in relation to human rights, right? I've seen your submission, CIL with Greenpeace. You focus a lot on the role of human rights, but also specialized areas within human rights, such as women's rights, children's rights, indigenous people's rights. And I think that in the decision, the tribunal does mention human rights, but it is quite a general observation. Climate change represents an existential threat and raises human rights concerns. But I was wondering, since your submission to the tribunal kind of emphasizes a lot the role of human rights in the whole decision, but how do you feel about perhaps I would say the absence of more engaged discussions in this? And you've mentioned the European Court of Human Rights, and I was wondering if you feel that perhaps regional courts are more progressive in this sense. Do they tend to apply more human rights to other areas of international law more than so-called international tribunals?
Thank you, Lisa. So I'll take those together, but I think one point that's quite important to start with is whether, if we look at the tribunal's decision, do we see, and the European Court of Human Rights decision in Klimascenerinnen, are we starting to see fragmentation or harmonization of international law? And international law in different areas, such as human rights law and law of the sea and climate change law. This is a question that is really, really important, seeing that we have all these advisory opinions in various courts and tribunals, right? But what we see with the ITLOS advisory opinion is that, in my opinion, it really has helped with this emerging harmonization and systemic integration of international law and law of the sea and science, etc. And this is when you look at it in comparison also with the Klimascenerinnen and what it could mean, especially for the Inter-American Court and the ICJ. And for that, there's really three main areas where there's starting to be at the international level as well, and more of a consensus or harmony on these issues. And these are the role of the best available science, the relationship between the climate treaties and general international law or specific agreements, and also the applicability of customary norms and international environmental law principles. So on the first one, on the role of what qualifies as best available science, what we see from ITLOS and also from the European Court of Human Rights has actually been done a long time by domestic courts in climate litigation. But judges in international courts and tribunals are taking notice, judicial notice, so taking as a fact, that the best available science as reflected in IPCC reports should inform the basis for decision makings. So in ITLOS, the tribunal found that the IPCC are the authoritative assessments of scientific knowledge on climate change, and noted especially that none of the participants challenged the authoritative value of these reports. And again said that the best available science is found in the works of the IPCC, and the science chapter of the decision of the AO relies almost exclusively on the IPCC reports. Similarly, the European Court of Human Rights relied on the IPCC as well as other sources of science, and really cited that states have to rely on the IPCC science in order to meet their obligations. And this is really important because based on the IPCC reports, both ITLOS and the European Court of Human Rights found that warming beyond 1.5 degrees would pose severe consequences to either the marine environment or to human rights of senior women. And ITLOS stating that in light of the broad agreement within the scientific community that if temperature increases go above 1.5 degrees, severe consequences to the marine environment would ensue. So there's definitely increased harmony and consensus on the role of the best available science for the other advisory opinions. The other point that was really, really important that when we heard the delivery of the ITLOS advisory opinion, when we heard this, we started cheering like it was a football game, is the fact that whether the Paris Agreement and the UNFCCC are lex specialis in respect to the obligations of state parties under more general provisions of the UNCLOS Convention. So lex specialis, if you don't know, is the principle that if there's conflict or if two legal instruments are focusing on the same area, then you go with the interpretation of the more specific legal instruments. So a lot of the high polluting states have argued that actually meeting their obligations under the Paris Agreement is sufficient, and therefore they also meet their obligations under the law of the sea or under human rights law in the case of the Klimaseniorinnen. And so the tribunal was very clear that the Paris Agreement is not lex specialis to the convention, and therefore the rule in Latin has no place in the interpretation of the convention. And we know that this is a very important finding of the tribunal. We know that most likely high polluting states have made similar attempts to evade their obligations under general international law in front of the International Court of Justice. And the tribunal reasoned in its rationale on this that even a supervenient treaty, and I quote, had an element of lex specialis to the convention, it nonetheless should be applied in a way as to not frustrate the very goal of the convention. And so, as an analogy, in the Klimaseniorinnen, the European Court of Human Rights also noted that states have a specific obligation under the European Convention on Human Rights to quantify their carbon budgets and policies for net zero emissions, and that this cannot be compensated by a state's reliance on its national determined contributions under the Paris Agreement, which is what the Swiss government was arguing. And therefore, ITLOS and the European Court of Human Rights have reached a point where they rightly understood Paris and UNCLOS, or Paris and the European Convention on Human Rights, as having separate sets of obligations, and hence satisfying the obligations under one regime and under the Paris Agreement, which has been criticized as quite soft in terms of obligations, does not mean that states have satisfied their obligations under another regime, which could have higher obligations, higher threshold of obligations. And this is also in line with the conclusions of the International Law Commission study group on fragmentation of international law and how international law should be interpreted with the principle of harmonization and systemic integration. And then finally, the third area where we're seeing this emerging consensus is really the applicability of certain customary norms and principles to the issue of climate change. So ITLOS confirmed in this advisory opinion what it had found previously, that there is a general duty to cooperate in the prevention of pollution of the marine environment under general international law, that there's an obligation to conduct environmental impact assessment, which is also a norm under customary international law, and that the precautionary principle should be applied to determine the scope of several of the treaty obligations of states, including the obligation of due diligence, the obligation to conduct environmental impact assessment, and the obligation to preserve marine environments. So all this is to say all the positive things that have happened and that we can infer from reading the ITLOS advisory opinion in light also of the European Court of Human Rights opinion. But as regard of your specific question on the human rights and the lack of specific human rights mentioned in the advisory opinion, well, we've mentioned now a few times that it's raised quite early in the decision that climate change represents an existential threat and raises human rights concerns. And we could see this as an exercise in self-restraint or judicial restraint by the tribunal when they're looking at an issue that is not fully part of UNCLOS. And we have seen declaration by other judges, including Judge Palvak, where they have expressed that they actually hope themselves that ITLOS would have gone broader in the implications of recent developments of climate justice. And specifically, Judge Palvak mentions the Klimaseniorinnen decision and the Billy decision by the UN Human Rights Committee. And similarly, Judge Chausssée's declaration says that that climate change represents an existential threat and raises human rights concern. But that our impression is that the court definitely is aware of these human rights elements, and we're not. And my interpretation is that it is also a response in terms of the criticism that the tribunal could receive if it had gone very detailed into what are the human rights interpretation of UNCLOS, but that there's enough good material there that we can definitely infer that there are basically human rights obligations, of course, when you're looking at climate obligations from the advisory opinion. So for instance, one element where in future cases, for instance, we could mention is that ITLOS mentions the need to assess socioeconomic impacts under environmental impact assessments, which can also be mean as a need to look at human rights impacts. When you're thinking of socio impacts, it's often human rights impacts, right? Similarly, the stringent due diligence requirement, particularly in the form of transboundary pollution, can be interpreted as human rights requirements. If we're looking at due diligence, it often requires as well to look at the impacts on human rights. And generally, we and so generally, even though ITLOS did not go as far as we had hoped it had been, and had been so explicit in the Arctic Sunrise, we do see that there is quite some elements for lawyers and people to work with in regards to human rights. And then the last question, and then I will finish, is whether we see that regional tribunals are more progressive. I wouldn't say necessarily. So these regional courts are human rights specific courts, right? They're meant to look at the human rights implication, whereas that's not the case with ITLOS. It's meant to look at the Convention on the Law of the Sea. However, what is true is that you often see a correlation between how open and how easy it is to access an international court or a regional court, and how willing that tribunal or court will be to look at human rights impacts. So, for instance, the Inter-American Court of Human Rights has taken the approach where it's inviting also impacted individuals and civil society to not only file submissions, but also be heard in court. Last week were hearings in Manaus, in Amazon, also mostly of impacted individuals. And this really gives a richness that unfortunately is not the case with some other courts like ITLOS, or even less the International Court of Justice, where submissions are really restricted to that of states or intergovernmental organizations. And there's creative ways, and World Youth for Climate Justice are doing amazing work to actually bring the voices of impacted people. But it's not the same as actually hearing from people themselves. So that is something that if those rules around participation were changed, I think we would definitely see more progressive interpretations of the law. Thank you.
Thank you very much, Liza, for those great questions, Tamara and Louise for your responses. And so now we're moving on to questions from Joachim, who's going to ask a set of questions to to Samira. And I know, Samira, that you had to leave a little bit early. But so what Joachim is going to do is also going to incorporate the last question that he had that was as addressed to the entire panel of speakers to you immediately. And then Joachim will also ask a closing question to Tamara and Louise. So Joachim, the floor is yours.
Hello, and thank you, Professor, and thank you all for the great work you did in relation to this advisory opinion. My question for Samira concerns the reliance on science in law. So it also touches upon part of Luis's response to the previous question. When discussing the scientific impacts of greenhouse gas emissions on the marine environment, ITLOS referred to IPCC as the relevant authority. And again, as Luisa mentioned, this was not disputed by any of the parties. And this, in general, feeds into a broader trend of the increased role of science in both domestic and international courts and tribunals. With domestic and international climate and environmental cases and many investment arbitrations, we can see that they're increasingly grounding their claims in science. And next to that, scientific grounds, often together with the rights of future generations, are raised in youth climate litigation. So my questions relating to all of that would be if you could perhaps speak a little bit regarding to the role of science in this advisory opinion and how the scientific findings were communicated. The second question would be how do you think the science might be better integrated into law and policymaking? It is a broader question. And the third question concerns the concept of youth engagement in litigation and in science. With the generation that grew up in the 2010s, when all of these subjects became more mainstream now, being in their 20s or 30s, how would you say, what would you say are the main differences in how young people engage in both science and policymaking? And then the question that I'll ask to all the speakers again at the end, I'm just gonna shorten it quite a lot here and ask you separately, what do you think are the main impacts of the advisory opinion beyond law of the sea, if there are any, and maybe how can the advisory opinion impact the advisory opinion of the International Court of Justice? The floor is yours.
Thanks a lot for this. Being mindful of the time, I will try to keep this as short as possible. And there are already some elements of answer that have been provided by the two other speakers, so that make it easier. But yeah, to answer the first question on the role of science on this advisory opinion, and particularly communication and scientific findings, what is important to note for this particular advisory opinion, and I'm sure it will be the same for all the other advisory opinion, is that science is at the utmost importance. The tribunal said it itself that the domain has a scientific aspect, and because of that scientific aspect, the tribunal find it necessary to delve into the scientific aspect of climate change. I'm going to quote here, but the tribunal says the phenomenon of climate change is central to the request, and the questions contained therein necessarily have scientific aspects. In their written and oral submission, the participants in the present proceedings addressed at length scientific aspects related to climate change and the ocean, and submitted and referred to abundant material on scientific issues. So we can see that science is really important from the beginning of this advisory opinion, and also we see it throughout the whole reasoning of the judges when it comes to giving their opinion. For example, for one of the most important and most awaited finding of the tribunal when it comes to the recognition of the anthropogenic greenhouse gas emission as a form of pollution, science and scientific findings played a crucial role in their reasoning. In paragraph 212, the tribunal considered that in the determination of necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emission, the science undoubtedly play a crucial role, as it is the key cause to understanding the causes, effects, and dynamics of pollution, and thus to providing the effective response. So here, in that particular reasoning, to admit that anthropogenic greenhouse gas emission are a form of pollution, science has been a key component in the reflections of the judges. But we are not only talking about science, like just basic science, but we are talking about the best available science. The term best available science is given 12 times within the opinions, which shows that this is really important, and the tribunal put an emphasis on the notion of the best available science. And even if they don't really elaborate too much in details on what is the best available science, the tribunal still note that with regard to climate change and ocean acidification, best available science is found in the work of the IPCC, which reflect scientific consensus. So because of that scientific consensus, the IPCC, as we have already said, is considered as the authoritative guidance uh, mechanism for this particular tribunal when it comes to best available science. And also, when it comes particularly on the communication of scientific findings, we have to really delve more deeper into the obligations that have been mentioned by the tribunal. In particular, one that I found interesting for that was the one that has already been mentioned by my colleague Louise on the obligation to cooperate. The tribunal indeed find that states have an obligation to cooperate. That stems from the Article 197 of the Convention, and its obligation to conduct. This is an obligation to conduct that must be done in good faith, and that duty to cooperate also means a duty to cooperation in terms of communication of scientific findings. Indeed, the tribunal is going to explain that states are required to cooperate to promote studies, undertake research, encourage exchange of information and data, and establish appropriate criteria for regulations. So for this is a perfect transition for the next question, which is on how science can be better integrated into policymaking and law, because the science even if there is like really various way that the opinion mentions, and there's various way that we can interpret this opinion when it comes to how to better integrate science and into law and policy making, we can see that, for example, for this duty to cooperate, it is clearly stated by the tribunal that science might be taken here as a way for cooperation and as a way to create rules, standard, recommendation of practice, procedure for the prevention, reduction, and control of pollution on the marine environment. It is also maybe important to come back again on the Article 194, paragraph 1 of ITLOS, where the tribunal states that parties of the convention have the specific obligation to take all necessary measures to prevent, reduce, and control marine pollution from anthropogenic greenhouse gas emission. And because the tribunal says that it has the obligation to take all necessary measures, it can be understood as in a way that it can only be done, all those necessary measures can only be done thanks to the best available science. And all necessary measures is also a due diligence obligation, which means that states have to put in place a national system to regulate polluting activities and to exercise vigilance to ensure the effectiveness of that system. So because of that obligation of due diligence and that obligation to take all necessary measures, science also plays an important role in the ways states need to put in place their regulations and norms. And I think that one other aspect that I would like to mention that has also already been mentioned before is that the tribunal also mentioned the notion of monitoring and in particular environmental impact assessments. Thanks to those environmental impact assessments, which are scientific method of understanding how if a destruction of the environment is going to occur or not, and how the environment is going to be impacted by an activity or human activity. We're going to make sure to see how science is at play and how we can use that assessment to create forms of regulations. And this is really a direct way to see how science can be understood to create law. And on the last question, on how the generation that grew on the 2010s, that are in their 20s and 30s, what will be the main differences on how young people engage in science and policymaking? I think that because we have grown with so much science around us when it comes to climate change, with more information that is more accessible in terms of language, content, format, specialization, has been a real democratization of science in general. This has allowed us to create more awareness on the urgency of climate, and that awareness has led naturally to the rise of more youth-led organizations that are trying to push the boundary of what we are told is possible by states. Organizations such as mine, but there's also a lot of others that are trying to use actually science-based science as a way to directly create norms and regulations, like with the advisory opinions. And I think that what is also understanding is that the more science has been available and the more people have used it in a way that has created more interconnectedness in our understanding of what climate change is. And there is not only one science. We know and acknowledge that some big reports such as the one from the ICC are really important, but we also try to look at other forms of what we can call science, such as the science that stem from indigenous knowledge. So I think that there is like a more intersectional understanding of what this can represent. So I think that young people at all levels are really looking and using science at all levels to help create the creation of policies and to help with the negotiations. And really, really briefly, and I will let my colleagues develop on that, when it comes to the last question on how this particular ITLOS advisory opinion is going to influence the others, I think that this ITLOS advisory opinion has been far more progressive than what we expected. The judge went point by point, really like a lesson, like courses that we can have in college, where they explain really their reasoning point by point. And I think that because they went so far, because, for example, they did not recognize that we should only look at the Paris Agreement, for example, when it comes to climate, but we should look at a whole bigger corpus of climate law. This forces the other courts to also do that work of going broader than what is Paris Agreement, for example. And I think that this is gonna be even more interesting because we also think that the Inter-American Court is going to be far more specific when it comes to human rights and also far more ambitious. So those two combined should maybe help push institutions such as the ICG to try to also go into details about the obligations of states and responsibilities of states. We hope that there will be mention of reparations, but also, for example, that they can go ahead and make some words on specific institutions that should be created, really go deeper into what states can do to answer to their obligations. Thanks a lot.
Thank you so much, Joachim, for the question, and Samira for your wonderful response here. And I am aware that we've gone a little bit over time. I would like to ask Tamara and Lou maybe to take 30 seconds maximum each to give some thoughts on Joachim's final question. So really, what do you think the influence will be of the ITLOS advisory opinion? Maybe more generally, but specifically on the ICJ advisory opinion as well. So maybe Tamara first.
Sure. Yeah, I think, I'd echo, I think a lot of what's already been said. I think hopefully this opinion will undoubtedly be influential. We're seeing like the tribunals already interpreted UNCLOS, which is also before cited in the request before the ICJ. It also drew from climate treaties, the IPCC, customary international law, lots of different bodies of law that are relevant and squarely before the ICJ, including just concepts that are applicable in different bodies of law around like due diligence. So I think the way it really set out that how due diligence needs to be objectively assessed, guided by the science, is going to be hopefully really influential for the ICJ opinion. There's also things that we haven't necessarily discussed as much, but about the guidance regarding the precautionary principle and false solutions, which will hopefully be important, as well as the stuff around transboundary harm. And even just more generally, I think, referring back to what I talked about earlier with the assistance and CBDR, I think additional affirmations around the obligations, that heightened obligations that developed states have, including their obligations around assistance, are really necessary if we're going to, respond to the climate crisis. So I think just generally these hopefully will be influential for the ICJ, but I think also hopefully in domestic and other proceedings, it will have a broader impact as well. So I think I'll end it there and turn to Lou as well.
Thank you. Maybe to go beyond like the climate field, I think it's quite interesting to look at the AO also for what it could mean for other kinds of environmental protection, like for instance, for deep sea mining or other biological biodiversity protection. We see that this stringent due diligence obligation paired with the precautionary approach to protect and preserve the marine environment, which includes the conservation and resilience of living marine resources, could be applied to other polluting activities in the marine environment. And we know that DSM is complicated because it's part of the UN Convention on the Law of the Sea, but I do have hopes that this is also used to stop activities like that.
Great. Thank you so much to all of you for joining today. Tamara, Lou, Samira, who's had to leave us already, Charlotte for giving for sending us her presentation in advance, and to Liza and for Joachim for engaging in these questions. I'm fully aware that we could not cover nearly everything in this briefing, but I do hope that this was a conversation that is going to continue. You might see that you'll find some email addresses in the chat in case you would like to get in touch with somebody and you can't find their email addresses. You can feel free to get in touch with me, and I'm happy to share. So thank you very much. Thank you for all the work that you have done and that I'm sure you will continue to do, and we'll look forward to seeing where all of this takes us. Thank you to everyone.